Now we're coming to our final session of the day, and indeed what a wonderful way for this final session to really bring together a sense perhaps of all that we've talked about today. We've heard a lot about the need for good corporate governance. We've heard about better risk management, trust and transparency, and indeed downright basic law and order. Regulations abound, of course, and while they're very welcomed in many ways, they must never inhibit business and indeed economic growth. So let's now take a look at the business perspective through the eyes of the legal department. And from Siemens, I'm very, very happy, very pleased to be joined by the General Counsel, SAIMA KHATTAK. And thank you so much. Sorry we're running a bit late. We really appreciate it. Thank you. Are you happy with the microphone, or you'd like to?
No, I'm fine with this. Thank you. Assalamu alaikum, ladies and gentlemen. Thank you for giving me this opportunity to share a few thoughts with you that would enable you to assess legal risks and to manage your legal costs. I'll try to keep it brief. I know it's been a long day for all of you. And if there's one thing that you all take away from this presentation, it's in terms of cutting down on your legal costs, please invest in a capable legal counsel. In-house counsels are still pretty new to the Pakistani organizations and for the large part are considered passive advisors rather than business active partners. Your legal counsel can save you millions in legal fees and legal costs on a yearly basis. Allow me to illustrate that point. Prior to joining Siemens, I had my own consultancy business advising various clients, primarily in the energy sector. I was approached by a client to advise on how to restructure and renegotiate a contract that was worth $500 million. They felt that they were not fully secure and not covered by the contract's terms. The in-house counsel was assisting me on that, a very pleasant gentleman with around 15-20 years of experience practicing as a litigation lawyer. I reviewed the voluminous contract project documents and correspondence, came back with a set of questions, and he could not answer a single one of them for me. That led to a series of meetings with the commercial and the technical people. And halfway through our meetings, I realized that the gentleman was rather quiet and had no contribution on most of the issues being discussed. I asked him about his opinion on what was being discussed, and he said, "Mujhe jis cheez ka pata nahi hota, main bolta nahi." Now right there is your problem. Had he been from the industry, had he known the business that he was in, the business he was supposed to be advising on, the nature of contracts and the transactions of his employer, there was no need for me to be there charging a very high hourly rate doing the business that should have been done by the in-house counsel in the first place. So invest in a counsel who knows your business. I would advise typically with at least 5 years of industry relevant experience, and then also go with a corporate lawyer rather than a litigator. You see, corporate law by its very nature is conciliatory, it's business friendly, and it tends to preempt, foresee potential risks that you may encounter while you're structuring a transaction. Litigation on the other side is more confrontational and aggressive. So what you need is a corporate lawyer who understands your business and your business needs and sensitivities, and who can advise you rather than simply acting as a post office and outsourcing all requests for legal assistance. Another manner in which you can cut down on legal costs, invest in research tools. We live in the technology age. It may not be cost effective for your company to invest in a full law library, and that's essentially what enables a lawyer to advise on various laws and how the courts interpret them. But it's a lot cheaper and a lot simpler to invest in legal research tools online, such as Pakistan Law Site, then you have Westlaw and Lexis, that give you access to laws and case precedents pretty much for every country in the world. The third item I would recommend would be invest in a good backup. By backup, I mean a junior associate who can shadow and be mentored by your senior counsel. This would give you a very valuable legal resource that is custom tailored to your company's needs. So in the event that your senior counsel either makes a career move or is temporarily unavailable to perform his duties, your business does not suffer. There's someone who can step right into his shoes and keep things running. My second recommendation for cutting down on legal costs would be, when you're negotiating and executing contracts, plan for the rainy days. The single biggest reason why companies agree to waive rights or take certain financial and legal risks is that at the time when they're executing these contracts, they are thinking in more amicable, friendly terms. They look at the other party and say, what could possibly go wrong? This is an international company that's been in the business for so many years, and they've never really defaulted or fallen short of their commitments. That's all fair right there and then, but there are a number of invariable, unknown factors that you have no control over, and it's the same thing for the other side. You should always provide for these. Do not waive any guarantees, any rights, any financial protections that you have in the contract simply based on the argument that you have good business relationships with the other side. Your argument should be based either on legal reasons or strong financial reasons why you can afford to take certain risk which you otherwise would not be required to take. Point number 2, timely assert your rights. It's always good to be in negotiation and avoid confrontation or disputes, but do so while you are fully aware of your rights. And even if it's a friendly notice you send to the other side saying, hey, I've noticed that you were supposed to provide X, Y, and Z by, let's say, March 30th, and you're slightly behind deadline. Even a friendly email like this would be proof later down the road that you did raise a claim or notify the other side of a potential breach. And this can be tremendously helpful to you if the matter ever goes to dispute resolution or to litigation. Another cost-saving method for you would be to develop templates for recurring transactions. This is most relevant for procurement contracts, for service contracts, and for hiring human resource as well. You do not need to renegotiate and draft a contract from scratch or pay an external counsel to do this for you. On the flip side, I would also strongly warn you against using templates or cut-pasting information into an existing contract for larger projects. No two large projects are alike, and I'll quote you an example on this. I was advising a local company on an alternate energy-fueled generation facility. They had received a claim for about 120 million rupees from the supplier, and they wanted to find out if there was a legitimate claim which they should pay. When I went through the contract documents, I realized not only was that claim not supported by the contract, but in fact the other side was in default and was liable to $40 million in penalties. The reason those penalties could not be fully enforced was they had taken a conventional fuel-powered project's contract document and tried to modify it for an alternate fuel source. This is how easy or how simple it is for you to lose out on a major amount of money. So never cut corners on legal costs where you must invest in a good lawyer and you need to pay whatever it takes to secure your rights going forward. I'm sorry, I'm not too good with this. Okay. Creating the paper trail. Once again, as I just mentioned, that we live in the technology age, and it's very helpful and time-saving for us to pick up a telephone and work things out over the phone with the other party should there ever be any disagreement over certain provisions of how we're doing business. That's all fine, provided you follow it up with a friendly email or even a text message or a letter. This is something that we ought to do and which I see business people most often slipping up on. Reason one, we live in a highly litigious society. You're vulnerable to legal challenge not only from your shareholders, your employees, your business partners, but the regulators such as the Securities and Exchange Commission, the Competition Commission, and whatever agency it is that regulates your particular line of business may also be monitoring you. If you have a persistent, continued record of all interactions you've had with respect to a project with the other side, you will have a way of proving your case should you ever end up in a dispute. Another purpose this serves